5 seconds to go. Start. Being aggrieved, the appellant and other co-accused challenged their conviction before additional sessions judge. Stop. The appellate court wide judgment dated 29th January 2005 dismissed the appeal and upheld the order of conviction and sentences as directed by the trial court. Stop. Para. Assailing the order passed by the trial court and the appellate court, appellant and the other co-accused filed criminal revision numbers 95 of 2005 and 89 of 2006. Stop. The High Court maintained the conviction with the observation that commission of an offence under section 409 of IPC has been proved because the agents were functioning under the instructions of the appellant. Stop. The depositors deposited the amount under a trust which has been breached by not refunding the same by the company. Stop. Thus, the court, while affirming the finding to prove the guilt of charge under section 420 IPC, also maintained the conviction for an offence under section 409 IPC, assigning the reasons that appellant has failed to show any authorization by the Reserve Bank of India, and other sanctions required from the Finance Department and also of other authorities of central government. Stop. However, the High Court, while maintaining the conviction, directed that the sentence so awarded shall run concurrently and the findings of the courts below to such extent be set aside. Stop. Para. Appellant, by filing this instant appeal, contends, the charges for an offence under sections 420 and 409 of IPC are antithetical to each other, hence the appellant cannot be convicted for both the charges. Stop. It is said the charges under section 420 of IPC is not made out since the prosecution has failed to prove dishonest intention of cheating, the appellant was only an employee and has been made a scapegoat for the purpose of selective prosecution, the ingredients of section 409 are not made out since the prosecution has failed to prove that the amount which was deposited was misappropriated by the appellant for his own use. Stop. Para. Per contra, learned counsel for the respondent has argued to support the findings recorded in the impugned judgment and urged the findings of conviction concurrently recorded by the courts below are neither perverse nor against the law and do not warrant interference by this court. Stop. It is said the ingredients for an offence under sections 409 and 420 of the IPC have rightly been proved in the instant case by the courts below, the argument regarding conviction of sections 409 and 420 of the IPC, both being antithetical, was never raised before the courts below, which cannot be permitted to raise at this stage. Stop. Para. Here, Mr. Avnish Kumar, learned counsel for the appellant, and Mr. Saurav Roy, Deputy Advocate General for the State of Chhattisgarh, and peruse the record. Stop. Before adverting to the merits of the contentions, at the outset, it is apt to mention that there are concurrent findings of conviction arrived at by two courts after detailed appreciation of the material and evidence brought on record. Stop.